Hello, Worth McAlister here. Today we are discussing Ricky Held versus the state of Montana, a constitutional court case held in the First Judicial District Court, Lewis and Clark County, Helena, Montana. The suit was brought against the state from the plaintiffs, which was a provision in the Montana Environmental Policy Act. They said that infringed on their constitutional rights. The provision was a climate change exception that helped the mineral and mining companies to extract more easily. They challenged the constitutionality of the provision, and what the provision did was prohibit the state from considering greenhouse gas emissions in energy related permitting projects to make it easier to get permitted. This was a group of young people from a trust that brought the suit against the state. Since then, they have brought other suits against the same state and other states, and a lot of similar cases have been inspired by this case. The defendants, however, argued against standing. Standing is a big difference in the United States, as we've learned, in comparison to Canada and other countries where there's a up and down of litigation, and a lot of litigation in the United States. But in cases like this, and in cases in the future where similar issues like climate change do infringe on the rights of individuals, which is a big part of the public trust doctrine and our Constitution. In our country, we can have the standing in some cases, but it's highly contentious. Who has standing, who doesn't? We have litigation to protect those. But the state argued that they did not have constitutional standing, they argued that the limitation that they say was unconstitutional, in fact, was not unconstitutional, and that they were just doing what the law stated that they were supposed to do, which was a legislative problem, not permitting. And they put this under the umbrella of a airing of political grievances, and that it was not actionable in court. So what makes this case historic? It was our children's trust. These were youth, age 2 to 18. It was the first climate-related constitutional lawsuit that made it to trial in the United States. Some had tried before, some currently are. What made it particularly historic is that they ruled in the favor of the plaintiffs. Judge Seeley on August 14th, 2023, did rule that they, in fact, did have standing. It was unconstitutional, and that they needed to remove the provision that allowed these permits to get pushed through more easily. And then it was upheld on December 18th, 2024. There are some other states that also have constitutional protections similar. Pennsylvania, Article 1, Section 27, that guarantees the right to clean air, pure water, and the preservation of natural, scenic, historic, and aesthetic values of the environment. Each state's constitution differs in their verbiage. Hawaii, Article 11, Section 9, clean and healthful environment. Illinois, same. Massachusetts, and New York. There is litigation in Hawaii, 2025. California has numerous ones. Hawaii has some others. New York, 2025. New Jersey, 2024. Virginia, 2025. Arizona, 2019. Washington, 2021. Florida, 2022. And Alaska, 2022. These are some of the ones from the current public trust claims and you can find that on the same website as the long orders of these trial summaries. And so it's interesting that all these fall under the public trust doctrine and our wildlife model in the United States, and how that affects our generation and future generations, which is a part of our rights. One parallel case was the Juliana case filed in the U.S. District Court of Oregon in 2015. It was permitted to proceed, filed by 21 young people again, sued the federal court this time. So this was against the U.S. And that included several branch officials for violating life, liberty, and property. The government they said the government was supporting fossil fuel interests and going against the duty to protect public grounds in a responsible manner for the individuals. And that was under the atmospheric trust litigation. And again, this was also our children's trust. Some of the implications for the future. Standing is the first one. It is up to interpretation whether or not a group or an individual has standing. There's a lot that goes into that. It's a delicate balance between tying up the court system, but even if they end up not having standing, like some of the current cases, it still shares the message that it's trying to be brought to light, and so it can have a positive impact either way. The defenses often argue that it's a abstract injury, hypothetical. There's no concrete injury, so that means there's no specific constitutional harm under MIPA. Each case is only binding in that state because each state has its own separate interpretation. But the news attention is successful in spreading the message. It's an interesting topic. And thank you very much.